Good morning from Tokyo, and good afternoon and good evening to attendants abroad. Welcome to Breakout Session 2, Impact on Territorial Issues and the Rule of Law. My name is Atsuko KANEHARA, professor at Sophia University in Tokyo, and president of the Japanese Society of International Law. I'm serving as the moderator for this splendid session. We have 4 speakers from Japan, Philippines, and US. Professor Masaharu Yanagihara, Professor Kentaro FURUYA, Professor Renato DE CASTRO, Professor James Kraska. They have various backgrounds: history of international law, law enforcement, US-China strategy, mainly in the South China Sea, and peace and security. I think that all the speakers and also all the attendants could access the program of this session and also could access the short bios of all speakers. So due to time restraint, I will not explain their short bios. This session will be realized as follows. 4 presentations. We will have 4 presentations continuously and followed by Q&A time. Then, I would like to ask Professor Yanagihara, the first presenter, to begin your presentation.
Yanagihara speaking, and I will be using slides, so I'm wondering if you will be able to see them. So, my theme for today is territorial issues of Japan viewed from a perspective of international law. International law, the history of international law is my expertise, and for 20 years I have been looking into the territorial issues of Japan mainly. And I would like to point out that in modern European international law, territory definition is used, and that kind of concept is unique to modern Europe. And before that, there were different views or different concepts in places other than Europe. So it should not be viewed as being identical. Now, next slide, please. So we talk about the problems of territory and disputes, but in terms of international law, there's only the term dispute, and problems or issues are not a technical term under international law. And when we talk about the dispute problem, there's the Northern Islands, Takeshima Islands, and the Senkaku Islands. Are there disputes? And among the relevant countries, the positions differ. And so whether there is a dispute or not, in the case of domestic society, you could resolve this with a trial. But in international community, there is not such a court. And therefore, ultimately, whether there is a territorial dispute among countries or not, who is going to make that decision? That is very difficult. And I would like to emphasize that at the outset. Next slide, please. So this is showing the territorial waters and the exclusive economic zone of Japan. You have the Northern Islands, Takeshima, and the Senkaku Islands, these 3 areas. And then the Northern Islands, that is 4 islands. There are 4 islands, and according to Japan, it's Wurup, Etorof, and between the 2, there is the border line. And this is Takeshima. And when we talk about Takeshima, you might think of just one island, but there is the Otokojima and Onnajima and a lot of rocky reefs. And this is the Senkaku Islands, and the biggest island is Uotsuri Island, and there is Taishoto and other islands. And the second major theme in modern Japan. So, what is the state territory? As I said at the outset, in modern international law, before it was introduced to Japan, we had something called hanto, which is the unique idea for Japan, and it is a state. It's different from the state territory in modern international law of Europe. But in the beginning of the Meiji era, there was the introduction of this concept. Actually, it was compulsory, it was forced. And so the state territory, in terms of the Western view, for the Meiji government, this was a very difficult issue. And in 1871, the Iwakura mission was dispatched to the U.S. and Europe, and there was a preparation for the mission. And one of the documents prepared was called Kosai Shimatsu no Koto and Kyokai no Koto, which is about Kosai Shimatsu no Koto is about diplomatic issues, and it deals with Korea and Ryukyu and where to draw the boundary, and then Sakhalin, Ulundo, and Ogasara. Where are you going to draw the border line? And then Ryukyu, presently known as Okinawa, it has a long history, and I cannot talk about the details, but in 1429, the Ryukyu kingdom became independent, and in 1609, the Satsuma clan entered, and there had to be land tax submitted to Satsuma clan. And then, on the other hand, Ryukyu also had a tributary system with China. And so it is a kind of a unique system which cannot be explained by modern international law. And from the end of Edo period to Meiji, how is this to be explained? This became a big issue, and initially there was the concept of belonging to both Japan and China. This is known as Ryozoku. And then from about 1872, there was a denial of this concept, and it was considered to be a dependency on the Satsuma clan, which is a view not in the modern international law. And so it just belongs to Japan. And then from around 1875, the Meiji government changed this way of thinking, and the state territory, or the European way of thinking, was applied. Going on. And then after that time, there was a disposition from 1872 to 1879, which is called the Ryukyu Disposal, and with the Shin Dynasty China, there were various negotiations conducted from 1879 to 1881, and the negotiations were not successful. And here, what was important is that in the negotiations with regards to the Senkaku Islands, there was no mention from both the Japanese side and the Chinese side, so this was not in mind at that time. And there is Ezochi, which is pointing to both Sakhalin and the present Hokkaido. So the control over Ezo in Edo period was again quite unique, not in the thinking of the modern international law, and vis-a-vis the mainland, it is different, a different type of control than the mainland. And the Matsumai clan was commissioned by the Edo shogunate for control. From the end of 18th century, there was the Russian threat towards Edochi, and so the Edo government had decided to take direct control. They changed their policy in 1799 so that the eastern Ezochi was the first under direct control, and the present four northern islands are included. And so the Edo government included the four northern islands at that time to put under control. And it was actually the Morioka clan and Hirosaki clan who did the actual guarding. And then after that time, in 1855, between Russia and Japan, an amity treaty was concluded. And in Article 2, the Urudo and the Etorof Island were where the boundary was drawn between the two islands, and the handling of Sakhalin was ambiguous. And the Meiji government, with regards to Ezochi, changed the name from Ezo to Hokkaido and included the Do in 1869. And there is the traditional delineation in Japan of 5 provinces and 7 do or districts. And for example, Tokaido is part of the 7 do. And it was named Hokkaido as the 8th do or district. And after that time, with Russia in 1875, there was an exchange treaty, and in 1905, a Portsmouth Peace Treaty. And then in 1951, there is the San Francisco Peace Treaty and abandonment of the Kuril Islands. And in the Kuril Islands, whether the 4 northern islands are included or not, between Russian and Japanese government, there is there a difference of view. And in 1956, there was a joint declaration between Japan and the Soviet Union. It is a treaty under international law. And after the peace treaty, it was agreement that Habomai and Shikotan would be handed over. And however, there was the new security treaty between Japan and the United States. And then the Soviet Union changed their position to that of no territorial dispute exists. And then for the next 30 years, the Soviet Union and Russia continued this position. But then Mr. Gorbachev in 1991 did acknowledge that there was a dispute, and there have been negotiations held after that time. But there was the constitutional revision last year in Russia, and when you listen to President Putin, it seems that he's trying to say that there is no dispute in existence. Next is I talked about the Ogasawara Islands, the isolated islands, and its incorporation into Japan. With regards to the Ogasawara Islands, in the Ogasawara Gunto, there were many foreigners who were living there, and so there were some issues. And then in 1876, ultimately, it was officially incorporated into the Japanese territory. Next, please.
Then, about isolated islands. What kind of projects were undertaken by the Meiji government? There are 3 major projects that I'd like to share with you today. First, from 1876 to 1879, the land register production was performed. This is not limited to isolated islands. In fact, this covered all over Japan, distinguishing the public or government land and privately owned land. And in 1877, on March 29th, the Udaijin, or Minister of the Right, Tomomi Iwakura, issued an order that the Takeshima and other island have no relationship with Japan, but whether the island that includes Takeshima or not, that is quite controversy. Then came the secret order of Yamagata Aritomo, Lord of Home Affairs, in 1885. And according to that, Daito Island and Senkaku Islands were investigated by that order. Then the third project took place in 1887. This was not led by Internal Affairs Ministry, but by the Tokyo Metropolitan Government. Iyo-to Islands and Izutorishima Island were investigated according to that program. Now, for those isolated islands, the procedures of incorporation actually come in twofold. The first is about the terra nullius occupation. That is in the case of Senkaku Islands and Minami Torishima Island in 1898. Another island is about reaffirmation of territory. In other words, they belong to Japan, but they reaffirmed that they belong to Japan. And that was applied in the case of Iyo-to Island, Torishima, as well as Takeshima in 1905. After that measure was taken in 1905 for Takeshima, the government of Japan implemented various measures, including the production of land register, incorporation of that island to Gokamura village, and collection of rent, granting a license for seal hunting, and also the license for collecting phosphorus resources. So that is viewed as the effective the jurisdiction or control of that island. And the South Korea, on the other hand, they call it Dokto. And in 1900, they issued the government ordinance insisting that the Dokto, or Takeshima Island, was declared as the territory of the Korea. However, it is described as Ishijima Island or Sokto, and whether this actually refers to Takeshima Island, there is no clear evidence. And there is no evidence whatsoever about the indication of effective occupation of that island. Doesn't exist around the time of that ordinance was issued. Now, the third theme, and this is the last, this is about the rule of law and peaceful change. Effective the 1st of February, the China Coast Guard law was implemented. I believe this is going to be discussed more in details by Professor Furuya, and therefore I will not elaborate on this. And there they talk about the sea area under China's jurisdiction, which is rather ambiguous, can encompass a broad range or the extent of the sea area. And it appears that under this law, various rights that are against the provision of UNCLOS seem to be provided for. When we refer to existing international laws, when it is somewhat inconvenient for a particular nation, the state or nation might have a desire to change it, but when they want to change it, by way of unilateral way or by force or coercive measures, if they attempt to change them, that should not be tolerated, and that is a very basic of the international law. And therefore, we should consider peaceful change. After the First World War, when the League of Nations was created, the peaceful change, the idea, was included in the covenant of the League of Nations, but it did not function. And then the similar concept was incorporated in Article 14 of United Nations Charter, and again, it does not function effectively. In other words, the peaceful change of international law is not yet materialized, unfortunate to say. And here, at this juncture, I'd like to introduce a Japanese diplomat named Minichiro Adachi, who served as the president of PCIJ, the first among Asian, from 1931 to 1933. Person by name of Louis Lamacus. He is a painter from the Netherlands, and he carried this cartoon on the Dutch the newspaper. And you see that there are two samurai warriors, one dressed gracefully in kimono and the other one dressed in armor. It was 2 months after the Manchurian incident in 1931. Adachi was greatly impressed with this cartoon. Back then, he was living in the Netherlands, and he sent this picture to two friends in Japan. And the painter, the Ray Marcus, was fully aware of the disaster of the war. He heavily criticized the outcome of such a war, and therefore he held great expectation toward the president of PCIJ. And you see that the samurai on the left is not armed, meaning that Ramarcus held expectation, a hope, but in a way that was somewhat not quite strong as a hope. But at least he wanted to raise a question of the legitimacy of resorting to force for changing the status quo. Well, Adachi was not an idealist. How slowly, not drastically, not by force, existing law and order could be changed according to the international law was the concept that Adachi maintained. He knew that international laws were not panacea, can't cure everything. Can't cure. For instance, in the case of a vaccine for COVID-19, of course, vaccine is not effective 100%, but at the same time, it is not chimera. That's imaginary monster. In order to maintain existing international order and further improve it, what we have as international law, that is the best that is available to us. So that's what the law embodies. If there is a dissatisfaction about the status quo, then there could be an attempt to change it, but not by force. I believe that is the belief that Adachi maintained. Sorry for taking up too much time, but this ends my presentation.
Thank you very much, Professor Yanagihara, for sharing with us very precious Japanese perspectives in relation to the keywords such as territory, disputes, peaceful changes, and the rule of law. You also finally introduced the Chinese Coast Guard law, which will be further analyzed by the next second speaker. Professor Furuya, you have the floor now. Please start your presentation.
Thank you. Thank you very much. Good morning, ma'am. Good morning to all. Firstly, let me express my sincere appreciation to the host, Jaya, for having me to this important symposium. I have the honor to be a part of the panel of seminar and distinguished scholars this morning. As Professor Yanagihara briefly mentioned, today I'd like to highlight the maritime security environment in the South China Sea and East China Sea vis-a-vis Chinese Coast Guard law. The year 2020 saw an escalation in the activities of Chinese Coast Guard vessels in waters around Senkaku Island, leading to the significant changes in the strategic environment. Chinese Coast Guard vessels showed their presence in the contiguous zone next to the Japanese territorial water of the Senkaku Islands for a record 333 days in 2020, almost every day. Intrusions into Japanese territorial waters around Senkaku Islands by China were recorded on 29 days last year. Among the intrusions was an episode in October during which Chinese Coast Guard vessels had stayed in Japanese waters around Senkaku Island for the longest record, 57 hours. Furthermore, there were 6 instances last year when Japanese fishery boats that were fishing in the territorial water were approached and harassed by Chinese Coast Guard vessels, prompting Japan Coast Guard ships to cut in between these ships to ensure the safety of Japanese fishing boats. And actually, there were 3 cases. There have been 3 cases in this year already. The Japanese government has repeatedly protested to Chinese government through diplomatic channels against such instances when China attempted to carry out activities that might seem like law enforcement targeting Japanese ships. Under such circumstances, what is known as the Chinese Coast Guard law took effect on February 1st this year. The Chinese Coast Guard was established in 2013 by merging separate law enforcement agencies such as China Maritime Police, the State Oceanic Administration, China Fisheries Law Enforcement, and the General Administration of Customs, and placing them under a newly reconstituted State Oceanic Administration. In 2018, the Chinese Coast Guard was restructured into an organization officially known as the Chinese People Armed Police Force, Coast Guard Corps, and placed under the command of the People Armed Police Force, which is supervised by the country's Central Military Commission. The Chinese Coast Guard was tasked with enforcing maritime laws and safeguarding maritime rights and interests without legislation in place to govern its activities. In November 2020, the National People's Congress unveiled the draft of the Chinese Coast Guard law. After being amended, the law was officially passed by the Congress on January 22nd and came into effect on February 1st of this year. Chinese Coast Guard law designates the Chinese Coast Guard as an important maritime armed force that is under the command of the Central Military Commission. As well as enforcing maritime law and protecting maritime rights and interests, the Chinese Coast Guard has also been assigned to carry out defense operations. This law is highly controversial among regional states. As Professor Tanaka, the president of the GRIPS, mentioned on Thursday at the very first session of this symposium, there are many issues, including the use of force in the maritime zones under Chinese jurisdiction, which is not always consistent with the United Nations Law of the Sea Convention, or UNCLOS. However, let me clarify that such legislation by the Chinese government itself does not constitute a violation of international law until the moment when such provisions are actually exercised. The Chinese Coast Guard law legitimates some Chinese Coast Guard activities that are not clearly based on the right on international law. In other words, Chinese government would ignore the legal rights and obligations under international law, but justify by a domestic law and make it as an enforcement issue. However, such activities would be legal only internally, but illegal internationally. The Vienna Convention on the Law of the Treaties, Article 27 provides that internal law may not be invoked as a justification for its failure to perform a treaty. Nevertheless, we do not have to wait until the Chinese Coast Guard ship takes measures that constitute a violation of international law. We should warn the Chinese government that it would be a violation of international law if such provisions are invoked. We even need to let the Chinese government, as a big country in the region, consider they should not have legislated such provisions. But let's take an example, Article 21. Article 21 provides a power to Chinese Coast Guard ships to take control measures over foreign warships or other government ships owned or operated by government for non-commercial purposes that violate Chinese domestic law in waters under the country's jurisdiction. According to Article 21, the Chinese Coast Guard may warn such foreign ships to leave the area or take measures to control the vessels. For vessels that refuse to leave and that may cause serious harm or threat, Chinese Coast Guard is empowered to take measures such as forcible towing of the offending warships. What if the provision is applied over the US warships engaged in the freedom of navigation programs in the South China Sea? Since Chinese law on territorial seas and contiguous zone prohibits foreign military vessels from passing through the territorial waters without obtaining prior permission, the US Navy warships sailing within 12 nautical miles from Chinese-occupied maritime futures would violate the Chinese domestic law. Then this article would authorize Chinese Coast Guard ships to carry out activities to force US Navy ships to expel from the waters in question. However, under international law, warships and government vessels operated for non-commercial purposes enjoy immunity from exercise jurisdiction by foreign states other than the flag states. Also, the UNCLOS does not have a clear provision to allow forcible measures against immune ships. Nevertheless, China Coast Guard ships may invoke Chinese Coast Guard law to justify such measures taken against foreign warships, which would be to challenge the existing legal order or international law by domestic law unilaterally. Now, let's move to the East China Sea. What are some of the implications for the security environment near the Senkaku Islands? Japanese and Chinese Coast Guard vessels sail side by side almost every day. And since last year, the trend of the situation has been worsening with an escalation in tensions. Besides, the Chinese Communist Party marks its 100th anniversary this year. Thus, it is possible that China may expand its presence in the East China Sea to enhance its national prestige. Considering such circumstances, it will become more necessary to ensure that accidents and incidents in the area do not escalate into something more significant by strictly observing existing international law. A hypothetical example would be a Chinese Coast Guard ship approaches Japanese fishing boat in Japanese territorial waters near Senkaku Island for boarding inspection or to carry out similar law enforcement procedures. At the same time, a JCG patrol ships cut into between the Chinese Coast Guard ships and the Japanese fishery boat to stop such activity. During this operation, there could be a collision between the Chinese Coast Guard ship and the Japanese Coast Guard ships. Now, Chinese Coast Guard ship could take forcible measures against Japanese Coast Guard ships authorized by Chinese Coast Guard law. These measures would trigger escalation at the scene. Until now, no such accidental crashes or incidents have occurred between Japanese and Chinese vessels in the area. One reason for this is that international law, including the rule of navigation and immunities, has been respected and well observed on a mutual basis. International law plays a role in preventing conflict by providing immunity to warships and government vessels that are carrying out their official duties. It urges diplomatic solutions instead of using forcible measures on the scene instantly. Therefore, in Japan-China high-level consultation on maritime affairs that have hosted a vote on February 3rd, Japan urged China to respect the provisions of UNCLOS and to ensure that Chinese legislation, including the Chinese Coast Guard law, is applied within the limit of international law. Faced with the challenges, Japan needs to enhance the capability it has in place for patrolling its territorial waters for the first phase. It will also become necessary to strengthen Japan's alliance with the United States so as to enhance extended deterrence. Increasing the cost of taking grave measures under the Chinese Coast Guard law and enhancing deterrence is the key. An effort also needs to be made to strengthen Japan's ties with nations that share values such as the rule of law and freedom of navigation, so as to rein in China's ambition and to ensure that such universal values are shared among the members of international society. I'm stopped here and I'm looking forward to have some discussion on this matter. Thank you very much.
Thank you very much, Professor Furuya, for your very timely analysis of the Chinese Coast Guard law. And these two professors and speakers dealt with their own main themes from mainly the legal perspectives. Then, I hope the third speaker, Professor De Castro, will connect the legal ruling of the South China Sea dispute and strategic concerns. Professor De Castro, you have the floor.
Ohayou gozaimasu. I have a PowerPoint presentation. Can we present? Okay. So first of all, I would like to express my appreciation for Jaya. I'm humbled by the invitation to be part of this panel that will be discussing, of course, the importance of international law in terms of the territorial disputes. My focus, of course, will be on the South China Sea, where you have power, the clash of power, and international law converge. Now, let me start. Dozo, please. First slide, please. Let me start my presentation by quoting from my favorite IR scholar, H. Carr, about what we call the positivist or the realist view regarding international law, which basically states that international law cannot be seen in abstraction when you have to look at the context of the international system or the international society. It is affected by strategic, diplomatic, and of course, political development in the international system. Unlike in the domestic context where you have international law being resolved by the court of law, in the international system, it is resolved by what E.H. Carr called the ultima ratio of international relation. And that is, of course, the military power and the clash of military power. Okay, let me start first. Next slide, please, Dozo. So when we look at the context, the geographic context of the South China Sea, we see the disparity. You have, of course, 4 littoral states, Vietnam, the Philippines, Brunei, Malaysia, and certain degree Indonesia, being confronted by a very powerful dominant state that is, of course, China. Next slide, please. Those on. So in the past, of course, you have chronic disputes, which I could still remember given my age, starting in 1975, when you have, of course, China using force against South Vietnam in the Parasols. Then later on, of course, in 1988 against Vietnam, and in 1996 against the Philippines when China occupied the Mischief Reef. Next slide, please. Dozo. So, of course, you have a change in the game. In 2009, China shifted from its earlier tactics of simply sitting there, doing nothing, to actively, of course, discrediting or, of course, challenging the claims of the smaller Southeast Asian states in the South China Sea. Next slide, please. Dozo. Of course, you have the China's use of the People's Liberation Army's Navy, the Air Force conducting numerous military exercises impressing upon the countries, the littoral states in the region, that China has de facto control of the South China Sea. Next slide, please. Of course, this has triggered disputes, especially targeting two small littoral states, Vietnam and the Philippines, the two countries that since the 2010 had experienced chronic crisis with China, as China, of course, impressed its de facto ownership of the 85% of the South China Sea. Next slide, please. And of course, this has caused alarm in Washington, D.C., primarily because of the fact that it affects the operation of the Seventh Fleet as it conducts its maritime operation in the first island chain, also challenging the United States' role in the region since 1945 as the offshore strategic balancer. And of course, challenging a treaty ally of the United States. And that is, of course, my country, the Philippines. Next slide, please. So you see this pattern of growing U.S. influence in the South China Sea dispute starting in November 2011 when then former President Barack Obama announced a strategic pivot to Asia. Next slide, please. Lozo. Then, of course, under the Trump administration, you have a shift in policy from simply rebalancing into the region to outright strategic competition with China. Next slide, please. And of course, from the perspective of the Trump administration, China is not a responsible stakeholder. China challenges the United States' role as the strategic offshore balancer, and it's a threat against what we call the rule-based international system, conducting several gray zone operations. Next slide, please. And of course, the United States Navy had to impress upon China that the United States will continue its role as the strategic offshore balancer, as the guarantor of the regional security in terms of its alliances, and of course, protect the rule-based international system. We can have the conduct. Last year, of course, you have, next slide, please, this massive show of American naval muscle, where you have two carrier battle groups converging in the South China Sea, basically impressing upon China that the United States is committed to the free and open Indo-Pacific region, despite, of course, of China's growing naval presence in the area. Next slide, please. Of course, this show of force was aimed to, as a background, as a backdrop, as the United States State Department announced that U.S. policy in terms of the South China Sea dispute would be based on, I would basically consider this a kind of forgotten 2016 United Nations Convention of the Law of the Sea award to the Philippines that declared that China simply has no legal nor historical basis to claim 85% of the South China Sea. I will later explain why it has become kind of forgotten. Next slide, please. So this is an unprecedented U.S. naval exercise of shore force, provided the symbolic backdrop to the United States alignment of its policy to the nearly forgotten 2016 arbitral ruling that basically declared China's 9-line claim in the South China Sea as illegal. So I think it's important for us to go into the history regarding this arbitral ruling. Next slide, please. So next slide. So where did this begin? Okay, we start with what happened in 2012. Next slide, please. I don't know if you still remember this, when you have this 3-month tense standoff between the Philippines and China over the Scarborough Shoal. And of course, in the end, despite a trilateral arrangement between the Philippines, the United States, and China, China reneged on its commitment to withdraw its ships, the civilian vessels, on the Scarborough Shoal. Forced into the situation, the Aquino administration decided to file a case against China in January 2013. Next slide, please. I'll just go to, next slide, please. So the Philippines requested an arbitral tribunal to issue 2 opinions on the following issue. Of course, regarding China's 9-line claim, and of course, the issue regarding whether the land features in the South China Sea constitute an island. Next slide, please. Tribunal, of course, petition also declared Philippines territorial entitlement, so forth and so on. Next slide, please. Let's go directly to the rulings. Of course, after nearly 3 years of waiting, the tribunal ruled in favor of the Philippines in 14 of its 15 claims against China's expansive territorial claims in the South China Sea. Next slide, please. Also, the court declared that China's claim, defined by the 9-dash line, defy and violate international law. The tribunal concluded whatever historic claims China had to the resources of the waters of South China Sea were, of course, diminished or extinguished when China joined the United Nations Convention of the Law of the Sea. Next slide, please. The tribunal ascertained, of course, in terms of the island. Let's proceed. I'm not a lawyer, so I'll rather look into the strategic diplomatic implication of the ruling. Next slide, please. So it is, of course, looking in terms of the strategic it potentially was a game changer when the ruling came out in 2016, transforming, of course, the strategic milieu of the dispute. What are those major strategic implications? Next slide, please. Number one, of course, it basically exposed China's claim has simply no legal nor historic basis. It is simply aimed to, of course, challenge the United States' role as this offshore strategic balancer and, of course, fragment ASEAN, which became apparent in 2012 in Cambodia, and, of course, coerce specific countries to simply accept China's de facto claim in the South China Sea. You have no choice, but they simply accept the fact that China, in case of the Philippines, China is your closest neighbor, simply because it controls, its maritime zone that is simply about 40 nautical miles from the Philippines' territorial waters. Next slide, please. Arbitral ruling, of course, revealed that maritime dispute between China and the territorial states is part of an old-fashioned great power competition, as, of course, China challenges the United States in the region. Next slide, please. Of course, it provides a division. Either you're on the side of international law upholding the arbitral ruling, or you're against it, or basically a revisionist, siding with a revisionist power that is, of course, bent on changing the status quo in the South China Sea. Next slide, please. The ruling could have provided a basis and motivation for cooperation among states that are threatened by Chinese maritime expansion. The law could have been a rallying point for countries that will have, realized that it pays to form a sort of a coalition that would uphold the law. Next slide, please. The legitimacy of the arbitral ruling, of course, alignment will have, of course, the basis for this coalition that will set appropriate mechanism, effective implementation of an old concept that was developed by Gerald Siegel in the 1990s. It's not containment, it's constrainment, which we can discuss later. Next slide, please. So what basically led to the fact that this possible game changers suddenly was removed from the table? Why did the arbitral ruling become nearly forgotten? And we have to give credit to what China have done ever since the ruling came out in July 12, 2016. Next slide, please. Of course, even at the onset, China indicated it would not join the arbitration. It basically discredited Manila for violating a non-binding 2001 declaration of the Code of Conduct when the Philippines, of course, decided to file the claim. Next slide, please. China, of course, reiterated its policy of dealing directly with the claimant states and, of course, always repeating the mantra of joint development. Next slide, please. China, of course, doesn't want to extend any legitimacy to the Philippine claim nor the tribunal, simply because it has all the cards on the table: economic prowess, diplomatic power, and, of course, growing strategic prowess in terms of growing naval power. why should it rely on the legal means to resolve the dispute if it has the realpolitik means? It could simply rely on clear, raw politic to resolve the issue according to its own terms. Next slide, please. So how did China basically undermine the ruling? By, of course, cutting a deal with a country that has filed the case in 2012. And of course, incidentally, what happened, when the ruling came out in July 2016, you have a change in administration in the Philippines. You have, of course, China cutting a deal with the incoming Duterte administration in terms of economic concession. And of course, a year later, offering ASEAN a code of conduct, on the parties in the South China Sea. Just breeze through this. First part, of course, is, next slide, please. You have, of course, initially the Philippines was excluded by China in the Belt and Road Initiative. But after you have the Duterte administration coming into the picture, China offered, of course, Philippines participation, membership, economic concession, if the Philippines would become part of the Belt and Road Initiative. And this fell basically into the goal of the Duterte administration to launch a massive infrastructure program called Build, Build, Build. I guess everyone here remembers in October 2016 when President Duterte visited China, the first country he visited when he became the president, President Xi Jinping promised him $24 billion in economic assistance. Next slide, please. Okay, let's proceed to the next slide. And of course, the other was, of course, a year after in May 2017. Next slide, please. The Code of Conduct for the ASEAN countries. I have nothing per se against the Code of Conduct, but in a deeper analysis, of course, the Code of Conduct doesn't resolve the issue. It simply manages the territorial dispute. And of course, since the negotiation began in May 2017, China had made it a point to also influence the terms of this Code of Conduct. Number one, of course, China's goal is to make sure that the Code of Conduct is not binding. And number two, of course, it aims to divide ASEAN into two. ASEAN countries that have an interest in the resolution of the South China Sea dispute versus, of course, the continental Southeast Asian countries who couldn't care less about the South China Sea issue. And of course, the third goal of China in terms of the COC negotiation is to exclude external powers like the United States, Japan, and Australia from the equation. Next slide. Next slide, please. Okay, let's proceed to the next slide. Next slide, please. So what happened last year? For the first time in 4 years, the Philippines finally acknowledged the award when Foreign Affairs Secretary Teodoro Locsin declared that the arbitration case initiated by the Philippines versus China is of a great significance. This is the first time that this administration has acknowledged the ruling after nearly 4 years. Next slide, please. Then, of course, he declared that the statement ends with an enigmatic caveat that the award is non-negotiable. Next slide, please. What led to the change in this administration position? Of course, China has simply did not reciprocate the expectation of this administration. And of course, it basically delayed and canceled funding in the various projects that China offered and promised to the Philippines in 2016. Out of the $24 billion promised by China, only about $164 million has been committed into a project, a dam, water dam project that has nothing to do with connectivity. And that's the Kaliwa Dam. Next slide, please. And of course, you still have this continuing coercive action against the Philippines. The one that really shocked the Duterte administration happened on February 17, 2020, when a Chinese corvette pointed its gun system director against a Philippine anti-submarine corvette, the PRP Conrado Yap. Next slide, please. Okay, let's proceed to the Biden administration. Okay, next slide, please. I don't know whether this was a coincidence. A day after, of course, the Philippines announced it acknowledges the claim the State Department came out with a statement aligning U.S. position in the South China Sea with the arbitral ruling. Next slide, please. Endorsing, of course, the United States accept that China has no basis to overturn historic rights or to make any other claim beyond those permitted by UNCLOS. Next slide, please. And of course, there's no indication that the Biden administration will change the current U.S. position on the South China Sea, as it's clear that U.S.-China strategic competition would be the heart of the Biden administration foreign policy. The focus will still be on China, trying to manage the competition and, of course, bringing allies not only in the region, but also from the North Atlantic Treaty Organization. Next slide, please. Of course, this stems from the fact that the root cause of the strategic competition is still there. China's increasing military spending, defense modernization, the air and naval provocation, China firing missiles into the South China Sea, and recently, of course, to show that it has the capability to challenge the United States' role as the strategic offshore balancer. It sent, of course, strategic bombers near Taiwan, basically impressing upon the United States, we have the capabilities to sink your carrier battle groups, impressing that the strategic challenge is still there. Next slide, please. Of course, from the Biden administration, China still presents a far more threat to the U.S., not only because of what's happening in the South China Sea, but it's offering a liberal alternative to American leadership in the Western Alliance and, of course, to the rules-based international order. Now, this is the last portion that's something to do. What will be the role of Japan? Next slide, please. Okay, so what's Japan supposed to do? Not only as, of course, a very important U.S. strategic ally, as a very important strategic partner of the Philippines. Next slide, please. But, of course, a country that, of course, indicated that it would like to uphold international law and, of course, uphold the ruling, the arbitral ruling, and based on the fact that the South China Sea issue should be resolved on the basis of international law, not on real politics. Next slide, please. It should encourage the Philippines and other Southeast Asian countries such as Vietnam, Malaysia, and Indonesia to take a proactive role in advancing the ruling as an important basis for eventual resolution of the South China Sea. This, of course, Japan might not be showing its military muscle, but Japan is still a respected power in Southeast Asia. Japanese soft power matters a lot in Southeast Asia, especially in the case of the Philippines, where, of course, Japan, despite the promise of China to provide $24 billion in official development assistance, Japan is still the largest donor when it comes to ODA to the Philippines. So Japan would have to rely on the fact that it is an accepted power in the region to encourage these countries not simply to rely on, to basically ignore, to take into account the importance of the arbitral ruling. Next slide, please. Of course, this is something that Japan has been doing, especially in the case of the Philippines. Provided the Philippines 12 Coast Guard vessels and also providing Coast Guard vessels to Vietnam and, of course, to Indonesia to basically challenge, China's use of its Coast Guard. We just mentioned the law earlier. Of course, there's an issue here in the Philippines regarding those donations provided by Japan. The current administration is using them to protect tourist spots like Boracay or deploying them in the Pacific area, but not in the South China Sea. Japan must impress upon the Philippines that those naval assets are aimed to uphold Philippine interests in the West Philippine Sea, to show the flag, and to uphold the rule of law when it comes to the South China Sea issue. Next slide, please. Encourage ASEAN that the COC should also be based, the negotiation for the Code of Conduct should also be based on international law with specific reference, of course, to July 12, 2016 arbitral ruling. Next slide, please. Impress upon the Southeast Asian countries that current situation in the South China Sea is not anymore a issue between China and, of course, the ASEAN countries, but other stakeholders in the region: Australia, Japan, India, the United States, and of course, the European countries all have a stake in the South China Sea dispute, not only because of just strategic issues, but also in the matter of upholding international law in particular and the rules-based international system in general. All countries that, of course, have maritime interests should be involved in the resolution of the South China Sea issue. And this will be my last slide. Last slide, please. Next slide. Here in ASEAN, there's still a resistance regarding the idea of a free and open Indo-Pacific strategy. Japan should engage the ASEAN countries and explain to the ASEAN countries the importance of a free and open Indo-Pacific region. Based, of course, on the three pillars: promotion of the rule of law, pursuit of economic prosperity, and of course, the realization of peace and stability. I think this is my the last slide. Last slide, please. Thank you very much, arigato gozaimasu, for giving me a chance to present my views. Matane.
Thank you very much, Professor De Castro, for your very interesting examination from a strategic perspective of the legal ruling by arbitral award on the South China Sea dispute, including the very important relationship between ASEAN countries and Japan. The third speaker mainly focused the South China Sea. I expect that the first speaker will mainly deal with the East China Sea. James, you have the floor.
Thank you very much to Gia and also to the moderator and my dear colleague, Professor KANEHARA. I'm glad to join with esteemed colleagues, Professor Furuya, Professor Yanagihira, and also Professor De Castro. It's a pleasure to participate. My focus is on collective responses to Chinese territorial aggression. And the point of departure for me, is that the territorial disputes in East Asia pit China's attempts at unilateral expansion against the territory of its maritime neighbors, and China's efforts to unilaterally change the status quo on land and at sea. China's efforts are part of a broader threat, principally founded by Russia and China, to diminish the rules and institutions that maintain international peace and security and that guide global cooperation. They're joined by Syria's use of chemical weapons, Iran's sponsorship of terrorism, and aiding North Korea's missile and nuclear programs in defiance of the UN Security Council. But I'd suggest that even as bad as Russia's invasion of the Ukraine was, that China's armed aggression in the South China Sea and East China Sea are actually the most compelling security issues in the world today. I focus on China's actions and suggest that they meet the legal definition of aggression in international law, and that the actions ought to galvanize states to respond to China and contain Beijing's aspirations. China observers frequently use the term coercion in relation to Chinese activities, but these efforts by China really fall within the definition of aggression and have to be understood and addressed as such on those terms. The U.S. alliance system of extended deterrence is the most essential element of a stable and secure Indo-Pacific regional order. This system is composed of the United States and bilateral treaties to protect the territorial integrity and political independence of Japan, South Korea, Australia, the Philippines, and Thailand. And all of these states have an interest in upholding freedom of navigation and access to the air and sea of the global commons, as well as to their secure borders. India and Vietnam are also strategic partners in this project to ensure stability and security. Among all of these states, I would suggest that Japan is the linchpin for security and stability in East Asia, and the US-Japan alliance is the most important security arrangement in existence in the world. Because of the disparity in power between China and its neighbors, the US-Japan alliance is more critical than even NATO. Because while China is larger in terms of population and military spending than all of its neighbors in East Asia, the largest NATO countries are more populous and have a higher military spending than Russia. Plus, remember that NATO is also supplemented by a separate, independent British and French nuclear deterrent. So the United States-Japan alliance is particularly important, and China's claims and actions in the region constitute illegal aggression. On land, these claims and efforts are against India. In the oceans, we just heard about the South China Sea, and potentially one day on land, China may look north to the Russian Federation and Siberia to recover lost lands under unequal treaties with Moscow. But the most compelling territorial ambition is China's aspiration in the Senkaku Islands. These islands provide a strategic wedge between Japan and Taiwan and the Philippines, and they advance China's claims to dominate the first island chain. They would become militarized, just like the South China Sea Islands, and used by China for power projection if China were to ever recover them. While most attention is focused on maritime claims, the greatest threat arises from these territorial claims. And the territorial and maritime claims form a package of challenges that unilaterally attempt to weaken the status quo, diminish the rule of law, and convert East Asia into a massive mercantilist zone that supports China, a modern, a contemporary colonial zone. Now, in international law, territorial claims may only be resolved through 5 separate means of acquisition. And sovereignty to territory may be acquired through conquest, but only before 1945. After the UN Charter, armed aggression is unlawful. Territory also can be acquired through accretion or geologic creation, such as volcanic action, or cession, that is transfer via treaty, where one state might give another state territory. States can also acquire territory through occupation of terra nullius and prescription of authority that is public and peaceful over a long period of time. This is not merely inchoate discovery, simply visiting an island on occasion. China's claims to the Senkaku Islands do not meet any of these tests and therefore lack a good faith basis in international law. The Senkaku Islands and Daito Islands were lawfully acquired by Japan in the late 19th century. The Daito Islands were uninhabited until the empire claimed them in 1885. The 8 Senkaku Islands were also terra nullius, and Japanese fishing vessels visited them in time historically and began to do so especially in the 1890s. And in 1895, they were incorporated into Okinawa Prefecture, where they had been managed and governed. These islands were leased in 1896 to Japanese nationals and sometimes sold to private citizens. After World War II, the United States administered the Ryukyu Islands and Daito Islands, and official documents by the US State Department and the Supreme Command for Allied Powers associated the Senkaku Islands with Okinawa Prefecture. Declassified records from the State Department note that the United States rejected in toto any Chinese claims to the Ryukyus that were raised by Chinese Foreign Minister at the time, Sun, in October of 1944. It's especially interesting that this was at a time when China was a US ally and Japan was a wartime enemy, and yet the United States still rejected those claims. Those claims were also rejected by the United States in 1947 when they were mentioned by Chiang Kai-shek. Similarly, in 1951, CIA National Intelligence Estimate concluded that adherence to the clauses of Cairo and Potsdam declarations would require the return of the Ryukyu Islands and the Bonin Islands to Japan. These were repeated in the Eisenhower and Kennedy and Johnson administration. In 1963, President Kennedy said, "I recognize the Ryukyus to be part of the Japanese homeland and look forward to the day when the security interests of the free world will permit their restoration to full Japanese sovereignty." Of course, that occurred less than a decade later with the reversion agreement when Okinawa reverted to Japanese, full Japanese sovereignty and governance. So the islands are Japanese, but China, as it has increased in power, has begun over the past decade to add additional challenges and take steps to undermine or to weaken Japanese administrative control. Bilateral relations between Tokyo and Beijing had a serious setback in September of 2010 after a Chinese fishing trawler intentionally rammed 2 Japanese Coast Guard vessels. China's presence and aggressive behavior over this area has been on the upswing. We've heard some of the incidents that have occurred in recent years, including just last summer, when Chinese officials informed Tokyo that Japan was not entitled to demand that Chinese fishing vessels and China Coast Guard boats leave the Senkaku Islands, the contiguous zone and territorial seas of these islands. This was a clear assertion of Chinese sovereignty over the islands in contravention of international law. All of these actions combined, the historic record, means that Chinese actions constitute aggression and a violation of international law and the Charter of the United Nations. In fact, also last year, Lieutenant General Schneider, commander of U.S. Forces Japan, declared that the United States is 100% absolutely steadfast in its commitment to help the government of Japan with the situation in the Senkaku Islands. That's 365 days a year, 24 hours a day, 7 days a week. These are alarming statements from senior officials. The reason why is because under Article 2, Paragraph 4 of the UN Charter, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. The threat of force under the UN Charter is just as unlawful as the use of force. This is lost on many international law observers, why they use the term unlawful coercion or Chinese coercion. It is unlawful aggression. Article 51 states that all states have the inherent right of individual and collective self-defense if an armed attack occurs. But the equally valid French version of the UN Charter says that individuals have the right, individual or collective self-defense, if armed aggression occurs. Armed aggression is part of the 1974 definition of aggression under the UN General Assembly. Resolution 3314 says that aggression is the use of armed force by a state against the sovereignty, territorial integrity or political independence. It says the use of armed force, including the China Coast Guard, the Chinese Maritime Militia, the PLAAF that purports to enforce an air defense identification zone, and of course the PLA Navy. It says that these constitute aggression if they're used in any manner inconsistent with the Charter of the United Nations. This 1974 UN General Assembly definition of aggression and the UN Charter are a combined rule set that China has violated. So we have collective action in order to resist this armed aggression. And there's been numerous statements and policy documents that Japan has led, beginning with the 2016 document on a free and open Indo-Pacific, where Japan bases its policies in the region on the rule of law, freedom of navigation, free trade and economic prosperity through connectivities and quality infrastructure development, not debt traps like the Belt Road Initiative. Japan was followed by the 2018 Australia White Paper that advances these same goals and seeks an international order that is governed by international law, the law of the Sea Convention, and the UN Charter. The recently declassified 2018 U.S. Indo-Pacific Framework has the same elements. Lieutenant General McMaster talks about how U.S. security depends on a free and open Indo-Pacific and how Japan seeks to dissolve the system of alliances that maintains that order. The United States seeks to increase the capabilities of Japan, Korea, and Australia, not control them. This is in internal documents of the United States, not seeking an exclusive arrangement like China, but an inclusive arrangement governed by the rule of law in which other countries are strengthened and empowered. These also include empowering and strengthening Japan, India, and the Republic of Korea, as well as the Philippines and Thailand, and even Taiwan. So one other thing that's very important about this declassified document is that it says that the United States seeks to align U.S. strategy with Australia, India, and Japan, not the other way around, not compelling these countries to align their strategy with the United States. So we have this collective end state. I'll end with the comment made last summer by the Defense Minister Taro Kono, when he said, when he was foreign minister, he was very careful in saying that China is not a threat. As defense minister last summer, he said that he was compelled to say that China has become a security threat to Japan. And indeed, I would suggest that the legal analysis supports his finding. Thank you.
Thank you, Professor Kraska, for your analytical viewpoint. And you put into the greater political and military context the territorial aggression by China in the East China Sea. And now we have some time for the Q&A session. And I have already received one question, and it is in Japanese, and it is particularly addressed to Professor Furuya. And I would like to translate at least the gist of the question to attendants and also speakers whose mother tongue is not Japanese. Does Japan need to amend the current Coast Guard law and self-defense law, and even create new law in order to effectively cope with this time tense situation, particularly caused by the Chinese Coast Guard law? I think that is the gist of the question. Thank you very much for the question. And first, and please, Professor Furuya, answer this question. And I would like to give the opportunity to make some brief comment to all other speakers, because Professor Yanagihara spoke about peaceful changes, and Professor De Castro spoke about strategic competition to cope with the legal ruling by the arbitral tribunal on the South China Sea dispute. And Professor Klaska spoke about military concern on the Chinese territorial aggression, particularly in the East China Sea. So from your excellent perspectives, not only Professor Furuya, but also all the other three speakers, I would like to ask you all to give brief comments on this question. And of course, you can widen the meaning of the question. For example, the gist of the question is the law enforcement measure enough to handle and to cope with this tense situation caused by Chinese Coast Guard law? But it is very important not to escalate the situation. So with this restriction, is the law enforcement measure effective enough to cope with this tense situation raised by the Chinese Coast Guard law? This is one example of the widening of the gist of the question given in Japanese. So first, I will give you the floor to Professor Furuya, and then Professor Yanagihara, Professor De Castro, and then Professor Klaska. Professor Furuya, please.
Thank you very much, Professor Kanehara Sensei, and thank you very much for the very important question relating to the Article 25 of JCG Act. Actually, that is that provision prohibits Japanese Coast Guard to be interpreted as a part of a military organization or armed forces, or the Coast Guard officials to be engaged in military functions. That is the essence of the Article 25 of the Japanese Coast Guard law. Well, first of all, I think it is not a matter of law, because this is kind of a confirmation provisions. Why? Because this article was stipulated right after World War II, and no Allied power want to Japanese remilitarization at this time. So there was a need to create this kind of provision. Nowadays, the meaning of the Article 25 non-military nature of Japanese Coast Guard is somehow changing, but still we see these provisions as important. And one more thing is that because this is confirmation provision, so if this provision is deleted, nothing will be changed. Because the JCG's function and duties are set out in Article 2 and 5 of the same Act. And then if you would like to change armament of JCG patrol vessels, then we need to change Article 4. So at least we did not change those provisions, Article 2, 4, 5, relating to the function and the duties and equipment of the JCG vessels. Nothing will be changed. And then now I think it is necessary to look into from the perspective of the function of the guarding territory or territorial seas. What is necessary? That is another thing. And then now we have the Maritime Security Operation and the JSDF Act, Japan Self-Defense Force Act, where the JSDF force
Thank you, Professor Furuya. Professor Yanagihara, you have the floor now.
はい、それでは時間の関係。
I have time limitations. I'd like to say one thing. Is the rule of law, and this concept originally was born in the domestic community in the UK. It was developed in the UK, and so this domestic society and also the international society, the emphasis would differ. And I think that should be understood. And particularly in Japan, this rule of law in international community, that means that you abide by international rulings. And people tend to say that, but that may not necessarily be the case. In the international community, when you talk about rule of law, there are the international law, which is created by nations, and that has to be upheld. And of course, there is the ruling of international tribunals, which should be abided, but at the base is the fact that you have to abide by international law. And so that should not be forgotten. And conversely, if you study international law, you are asked, why should you uphold international law in the first place? And one answer is that it was created by nations in a sense. It was created so that it could be adhered to, and so it is strange that it cannot be adhered to because it was created to be adhered to in the first place. Well, it's difficult to say if this is correct or not, but what I want to say is when you talk about the rule of law, the domestic situation and the international society, it's not necessarily the same emphasis, and I think that should be understood. That's all.
Yanagihara for broadening the concept of the rule of law. And Professor De Castro, now you have the floor. Microphone, please.
I'm sorry. Looking at it from the perspective of the Philippines and Southeast Asia, actually, we are fine with the current status of the Japanese Coast Guard. Because of the civilian nature of the Japanese Coast Guard, it's easier for Southeast Asian countries to cooperate with the Japanese Coast Guard. In contrast, of course, if you look at the cooperation between the Philippine Navy and the Japanese Maritime Self-Defense Force. So in fact, in terms of our cooperation with the Japanese Coast Guard, it's great. I could still remember in 2006, when there was an oil spill here in the Philippines in one of the islands, we asked the assistance of the Japanese Coast Guard. What probably should be looked at would be in terms of the attitude regarding the Japanese Coast Guard, that sooner or later we will have to assume an expansionist role, not just in the, in Senkaku, Daiau area, but also in Southeast Asia. It will have to show to the Southeast Asian countries that you have to also build up your capabilities, because you have to challenge Chinese maritime expansion. Also in terms of course, in the case of the Philippines, we received 12 Coast Guard vessels, but then you have the problem regarding, is this being used by the recipient government for its intended purpose? So there's also an element there of moral suasion. It's not just a matter of providing the hardware, but basically telling the country, advising the country, we provide you Coast Guard vessel to challenge China's maritime expansion, not simply to appease China. So this is, of course, this is a tall order for Japan. But Japan, of course, is a trusted country in the region. People would listen to Japan because Japan knows how to convey the language, among Asian people. Thank you very much for your attention.
Thank you very much, Professor De Castro. And next, please, Professor Klaska, you have the floor.
Thank you, Professor Kanehara. I would just add, all great comments. In our conception of international law, there is a law of peace and a law of war. And this goes back to at least to Hugo Grotius, if not before. So 500 years of international law or more. And we view peace as the norm and armed conflict as an aberration. And in fact, my view is that China understands that we are engaged in a continuous, a spectrum, a never-ending struggle for power, a systemic struggle for power, in which China is accustomed to mixing elements of war and peace together, such as continuous, relentless cyber espionage, economic mercantilism and economic warfare, 5G, the fight for 5G and standards for 5G, withholding of rare earth metals, cultural influence, election interference. All of these things are alien to our countries, but they are part of the Chinese mindset because they're authoritarian. In the United States, we also, of course, have a separate Coast Guard. But to underscore the separation, the Coast Guard is part of the Department of Homeland Security, and the Navy is part of the Department of Defense. Now, it is true that during these exceptional periods of armed conflict, the U.S. Coast Guard can operate under the Department of Defense, such as it did during World War II. But these, again, are considered exceptional. So we all have to collectively figure out how we can better integrate these forces. And it's not easy to do, because just one final example is that the Coast Guards operate under maritime law enforcement rules that are dependent upon human rights law and rules for the use of force under human rights law, the same laws that police officers would employ. Whereas armed forces or military forces may use rules of engagement. And it's a very different setting when you have rules of engagement that allow, during armed conflict, status-based targeting. So this is something that we still are unable to figure out. And then China in particular, as well as Russia and Iran and North Korea, are able to exploit this seam or this weakness in the way we think.
Thank you very much, Professor Klaska. Now we are almost at the end of this session, and please give me just 1 minute. We had very excellent 4 presentations, and also we had very fruitful discussion with the question raised by the attendant. So I think I do not need to make a long conclusion. Just briefly, I would like to make 2 points. One, as a key player, particularly in the East China Sea, Japan, with its long history of the relationship between China, needs to maintain the ocean order by law enforcement measures. 2, we clearly understand that territorial challenges caused by China has seriously raised concern about security in both South China Sea and East China Sea. Therefore, in order to solidly realize the rule of law, strategies from various perspectives are really needed, as being reflected by the distinguished 4 speakers. All the attendants who logged in, please join me, even online, to give big hands to all 4 speakers. Thank you, all the speakers and all the attendants. The session is closed. Thank you.